evening. Thank you for being here today at the last panel of the day, of the last day. So you are very brave and interested in this panel, I would say. So thank you so much. The panel is organized in the context of AltPTP project, which stands for Articulating Law, Technology, Ethics, and Politics, issue of enforcement and jurisdiction of EU data protection law under and beyond the GDPR. So just AltPTP, it's easier. I'm Rocco Saverino, a member of LSTS at the VUB and a doctoral researcher. And today we are going to discuss overenforcement or underprotection and the role of the AI office in this context of enforcement of general purpose AI rules. I have a very great panelist today with me. From my left, I have Pavel Ajduk is a EU qualified lawyer and an external data protection officer, and also PhD researcher and lecturer at the Department of Informatics Law at Cardinal Stefan Wisniewski University in Warsaw. Sorry for my bad pronunciation.
It's fine.
Then Sophie Staya-Bourdillon, which is co-director at the Brussels Privacy Hub and a member of the LSTS research group. She's also a visiting professor at the University of Southampton, and she has a lot of experience also serving like expert at the European Commission, Council for Europe, and many other organizations. We also have Claudio Teixeira, who is a senior legal officer, deputy head of digital policy at BEUC, the European Consumer Organization, as you know. Is leading its work on telecom and AI. Last but not least, Sabrina Kuspert. She is a policy officer at the European AI Office. And in her role, she focused on setting up the governance system for general purpose AI. Before starting, I would like to also thank you not only the CPDP organization for the great job, but also my colleague Michael van der Pol, who helped me with the organization of the panel. And now, finally, we can start. I would like to start with Sabrina. Considering that we're going to talk about general purpose AI rules and the AI office, I think you deserve to be the first. Well, in this case, we have a presentation, and my question is, how will the centralized enforcement of general purpose AI rules within the AI office operate in practice? Particularly in balancing the dual objectives of promoting innovation and safeguarding individual rights. And also, what role have in this context the advisory forum and the scientific panel? So I think you can start. We have already a presentation.
Thank you very much, everyone, and thanks for being here on this Friday evening. As Rocco mentioned, I'm going to talk about the AI Act and how, through the AI Act, the ambition is to create trust along the entire general purpose AI value chain. We can go to the next slide. Maybe. No? Yes. Brilliant. Okay. So let's zoom out for a second. In February at the AI Action Summit, our President Ursula von der Leyen put into perspective what we're trying to achieve in Europe with regards to AI and also general purpose AI. She referred to the fact that ever more powerful AI models are being released to the European market and globally. Some expect that these models might approach human reasoning within a year's time. So we're at a point in time where there's a lot of fast progress in AI and especially advanced AI. through the AI Act, the European Union already put forward an idea how to ensure that AI will be safe, and there's also some consensus in the international community about the aim to achieve that. At the same time, it's now for us to decide, what's the vision of where we want AI to take us? And here the idea is that Europe should be one of the leading AI continents. And the approach that the European AI Office takes to general purpose AI should support this holistic vision. Today I'm going to talk about a brief recap. How does the EU AI Act ensure trust along the value chain? Then I'm going to give some updates of how we work right now on simplifying rules and ensuring effective implementation of the AI Act. And ultimately, I give a brief outlook on how we're working towards a European AI continent where we can build on our strength. I'm sure most here in the room are AI Act experts. And so you do know that the AI Act is the first ever comprehensive legal framework on AI. The idea is to acknowledge that AI can lead to very good outcomes for Europe, but also there are some risks that in certain applications or use cases there could be negative outcomes, which we want to avoid. And therefore, there should be a harmonized approach across all 27 member states so that there are harmonized rules, and it's the same whether a company operates in Germany, France, Sweden, they follow the same rules for AI. And this should ensure that startups can be as trustworthy as large corporations because they follow the same rules. Users can trust what AI has to offer because there can be more demand, and trustworthy AI, and in general, gives access to the entire European market. Now let's deep dive on general purpose AI. So the technology experts amongst yourselves will know that it's a trend that we see that ever more powerful models are being integrated in a lot of downstream applications nowadays. So there are few models that are being integrated across different use cases and applications. The AI Act takes the approach that we want to ensure that the entire value chain, from models to systems, is guided in a trustworthy way. You see here to the left our approach to general purpose AI governance, and to the right the approach that we take for specific use cases. If we start to the right, you will see that we acknowledge that for the vast majority of AI systems and use cases, there's minimal and no risk, so they are all permitted on the European market, no rules needed. For some, there's a certain transparency risk, for example, when you interact with chatbots or when you might see deepfakes. And here we want to ensure that these systems are subject to some transparency obligations. Even fewer use cases might pose high risk in Europe. So, for example, when a company uses an AI in recruitment, then we want to be sure that there are some additional checks and balances, humans in the loop and the like. So there are these additional requirements. And ultimately, we do acknowledge that there are some AI systems that might pose unacceptable risk, and they should be prohibited from the European market. The focus of today is more upstream of this use case, of these use cases. Here it's about the models being integrated in systems. Because there are few models that may be integrated in these systems, we want to ensure that everyone building on these models has the right level of information needed. So, for example, ensuring that there's the right level of transparency, but also ensuring that copyright-related rules are respected. In addition, we say that for some general-purpose AI models, these could lead to potential systemic risks to the European Union. And here, additional safeguards are needed. This is really for only the few most advanced models. And the idea is that, for example, risks in the domain of biosecurity, cyber attacks, loss of control, but also potentially discrimination at scale and the like are being addressed. And right now, we're detailing out how the general purpose AI rules should apply in a so-called code of practice that you might have heard of. This is being developed together with independent experts. I'm going to touch on this later on. Quick recap as well, you might know it, rules for general purpose AI models are being enforced at the EU level, so by the European AI Office, because there are only a few models that are being applied across Europe, while the rules for the AI systems, the specific use cases, are being enforced at the national level. We do receive support from the ecosystem for this. So, for example, through the scientific panel, which will be set up soon, we will engage with independent experts that can alert us, for example, of systemic risk, but also provide a link to the scientific community in general. The advisory forum should help us to engage with the stakeholder community more widely and receive their input. And the AI board is another governance mechanism that just ensures that both the EU level enforcement and the national implementation go hand in hand. Brief updates, how we're working towards simplifying rules and ensuring effective implementation. We are working towards a bolder, simpler, and faster union, so it's one of the priorities of our political leadership that the AI Act should be more streamlined. Specifically for general purpose AI, this happens through the code of practice that I've mentioned briefly before. This is a process to detail out the rules for general purpose AI models, so both the transparency and copyright-related rules for all models, but also the ones for risk assessment and mitigations for a few providers that want to put their models on the European market. It's quite unique because the pen holders are independent experts. So, for example, Joshua Benjo or Marietje Schaake are experts amongst 13 that lead this effort, and they're engaging with around 1,000 stakeholders. This process started last summer, and the code should be published ahead of August when the rules for general purpose AI start to apply. We're right now in the final phase of the drafting, so you might have heard it in the news. So everyone's looking forward to this final document that will be published, because it's the first time that within a legal framework, rules will be detailed out what it means to safely and in a trustworthy way develop and deploy general purpose AI models. And at the same time, it should be a tool for providers to demonstrate compliance, so it should help them to comply with the AI Act, because they can also demonstrate compliance through other means. A brief spotlight on other initiatives that are currently going on as we're getting ready for rules which start to apply from August 2025 onwards. We are clarifying key concepts in guidelines. We do understand that there's a lot of desire from industry, but also other stakeholders, to understand what exactly the scope of general purpose AI rules are. So until yesterday, we had a consultation open where stakeholders could react for a month to our proposal, and we're now detailing this out, and it should be published also ahead of August. At the same time, we're setting up other initiatives to engage with the ecosystem, for example, a network of evaluators to share expertise and advance the science of how third parties can evaluate the risks from general purpose AI models. We're also building up our technical infrastructure to ensure we have the relevant procedures in place and the relevant expertise. So basically every few weeks, new colleagues are starting at the AI office, policy, legal, and technology experts that focus on this technology before. And we're setting up our governance structure, so in particular the scientific panel, but also the advisory forum, and there will be some information published quite soon. Last but not least, a very brief outlook to where the European AI continent should lead us. With the AI Continent Action Plan, we put forward 5 big pillars of how the Commission wants to support the way for Europe to take on leadership in AI. First, we're building out large AI computing infrastructure. We're also increasing access to high-quality data. It will be specifically important to support AI uptake in strategic sectors, so for example, in the public sector or healthcare or other crucial areas of application. We're strengthening AI skills and talent to attract new talent, but also to retain the great talent base that we have in Europe already. And the third pillar we discussed now more in detail, which was about simplifying the implementation of the AI Act. Thank you very much, everyone.
I'm going to stand. Thank you, Sabrina. Thank you so much, because from this we can see that there is a lot of work that you are doing, and there is a lot of, you are doing a lot now, and I think you are doing, you need to do, you need a lot of, you are going to do a lot of work in the coming months, but also, you know, when I saw simplifying, let's say, tackle to the AI Act, I was thinking about the other digital regulations. Sorry. So, talking about other digital regulations, I think that Sophie can address this this interaction with the existing EU digital regulations, particularly the GDPR, but also the DSA, the DMA, the Data Governance Act, and what risk of overlaps we have there. What contradiction or fragmentation in enforcing general purpose AI rules. I know that it's a very, I mean, if you have this answer, probably you are going to resolve all the problems, but still, I think you can do it.
It's the story of a life. How am I going to tackle this question? I was not expecting so many people in the room, so I try to improvise just a little bit and explain the problem with the following, which is a short story about only three, sorry, Rocco. Some of the regulations that you mentioned, I don't really believe very much in them, say DGA, for example. So I've been selective, and I will look at three of them. So how is my story built? So it's a tale of three regulations. So it starts like this. Once upon a time, we had a sort of a big mess, so I'll start with a mess. Lots of different chapters in the EU Digital Rulebook, at least if you look from far away, or maybe this is a better representation. The claim that I like to make is that meaningful enforcement requires awareness of rule interdependency. I'm not so much against overlap, but I'd like to make sure that there is awareness of the different chapters so that we can hopefully reach a positive result when we try to enforce all these rules. So what do I mean by rule interdependency? Rules form a network of interconnected obligations that must be aligned. That's, I think, how we could maybe solve the conundrum. By align, I'm not saying that we need to eliminate overlap. As I said, we are at a stage at which I think if we work together, we will probably, hopefully, be in a better place. Maybe we are going to solve some of the problems that we've had for several years, for example, in the data protection space. We shall see. So we need in-depth engagement with the different chapters. We cannot just work in silos and just speak about the AI Act in isolation, I think. Otherwise, we'll go into the wall. So rule interdependency, just to go back to that concept, I distinguish two things here, enabling interdependency. Some rules have been adopted to some extent to help compliance with other rules from other chapters, I think. And then we should also be thinking about impacting interdependency and making sure that the rules adopted in one chapter are not indirectly undermining the effectiveness of other rules. So let's start with the AI Act, yes, because this is where we start. This is where the buzz is. One question among many other questions is what is the interplay between the AI Act and GDPR? Some answers this question by look for the magic words, the without prejudice words. Actually, they are mentioned 60 times in the AI Act, but who cares? Let's look at Article 2, where you do find the words without prejudice in there. But they are not exactly used for GDPR as a whole. what we find is that the regulation, the act, shall not affect the GDPR. And nota bene, we also have the same thing with DSA. What I'm trying to say here is that there is more than the without prejudice clause. There is the word facilitate. And this word you find in recital 10, for example. This regulation should facilitate the effective implementation, enable the exercise of data subject rights and other remedies. You also find facilitate in other places, like in recital 67. There are governance and management practices that we are governing through the AI Act should also be quite useful for complying with the GDPR. And nota bene, you also have the word facilitate for in relation to the DSA. So if I try to draw a very simplistic diagram of all the very many words that I've been showing on the screen, Article 10 of the AI Act, in theory, facilitate compliance with GDPR. Same thing with 13, I'd say. Okay, that was for the framing. I know that the purpose is to discuss general purpose AI, but I wanted just to set the scene because Rocco asked me to speak about overlaps between all these different pieces of the puzzle. So general purpose AI models, what do we have there? We have lots of transparency rules, some about also mitigation. Talking about transparency, yeah, this is me pondering. Is enabling interdependency always on the agenda? I'm wondering. If I'm looking at Article 53, it should facilitate compliance with GDPR. And indeed, so a bit more words, if you look at Article 53, you will see that there's some documentation that needs to be produced for national competent authorities, but also for providers of AI systems down the stream. They need to be able to, when they use base models, to have a good understanding of the capabilities and limitations of the general purpose AI. That being said, when I look at the documents that have been produced so far, I know there are iterations, we are not finished just now, but it's not always very clear why all this information that we need to produce is not directly benefiting the downstream providers and the public generally, because we have downstream providers, but we also have lots of use cases in which models could be used to play with, and then we need information prior to have the official labeling of the role, I think. And indeed, there is a D to my Article 53. There is also some information that needs to be made publicly available to a sufficiently detailed level about the content used for training the general purpose AI model. And again, if we look at what we have so far, but we will get more soon, hopefully, I'm not entirely sure that the interplay between the AI Act and GDPR has been fully understood, and we've done all what we could to facilitate compliance with GDPR. Hello, GDPR. So why is it I'm asking this question? That's because well, GDPR applies to AI-driven practices for quite some time. And our DPAs have been working and trying to determine how we should be implementing this framework in this particular use case, or a variety of use cases, if I am to say it better. And we've had an opinion in particular back in December trying to explain the implications of data protection in the context of AI models. And there, yeah, that was my first reaction when reading the opinion. But let's go further. If we try to summarize what is it that we get in there, I did try to do that, and not so much in a very long academic piece, like in 5 pages. Tried to clarify as much as I could, and that's what I extracted. Users of base models shall produce a risk profile for their use case and then perform some due diligence upon the general purpose AI model that they are using. So they need some information, otherwise it just doesn't work. So Article 53 should really be useful for complying with GDPR. I have Article 5, but say the whole GDPR here. And indeed, just to quote the relevant paragraph in the opinion 129, we need to make sure that where am I? Yes, that the AI model was not developed by unlawful processing personal data. So yeah, down the value chain, each node needs to disclose some important things. Otherwise, this is not going to work very well. Oops, yeah, this is turning, I don't know why. Go back to general purpose AI models and a few things about mitigation. And here I want to bring in the DSA because the DSA says says substantial things about systemic risks and also about mitigation measures. But some people are crying because they've been reading the first reports that have been produced, trying to make sense of Article 34 and 35, ways that they are crying. I'm exaggerating, of course, yes, because there's not full transparency about how these big players are behaving. And there's lots of things that are actually missing in terms to be able to assess these risks. So in this particular piece, we find lots of useful recommendations for metrics and disclosing elements that would be helpful for the analysis. So we are not there yet, that's for sure. So if at the model level we have a very narrow understanding of systemic risks, then this is not going to be very helpful for what's going to happen to the AI system that is leveraging the model. And indeed, what we find in the most recent version, but I'm being told that this will change, hopefully, to which extent I don't know, but we have a very narrow understanding of systemic risk. Systemic risk, where are you? So we have not fully understood what I would call impacting interdependency, but that's my jargon. A last point, and I will finish on inconsistency rather than interdependency, or maybe it's just preliminary confusion. Who knows? We'll shall see. So that's my golden question. It's also shining. So what should we make, for example, of Article 10.5 in the AI Act in a DSA context? So we know we have high-risk AI systems, and then we know that we have general-purpose AI models that can produce systemic risks. So we have models, we have systems, and then we have the DSA. What's the DSA? We've got some recommended systems in there, AI systems, that can generate systemic risks. Okay. And then we have some rules about, in this particular use case, so this is just an example about special category data and what is it can be done with the special category data to do some detections about bias, for example, which relates to systemic risk if you want. So we need to understand what's the interplay between Article 10.5 and GDPR, but we also need to understand the range, the leeway that we give also to our VLOPs and VLOs when they have to comply with Article 34 and 35 of the DSA. Just putting that on the table. So to conclude, just with this not so beautiful picture, I think it's important also to look at the details, but not to forget the big picture. And I would advise, but I'm sure that has been told many times, that we need to look at these different chapters together and try to understand what the castle is actually looking like. Otherwise, yes, the healthy balance is on the side of the big picture, not so much on the side of the details. But I want to be optimistic. We'll make it work. Thank you.
Thank you, Sophie. I think you did it. I mean, it was quite complex to design a good answer to these questions, but I mean, now it's a mess. We know that probably we will have some overlaps. We are worried about it. We heard this in other panels also, and but the good thing is that we are discussing and we are trying to, to discuss about this, to try to find, I'm not saying a solution, but to bring up what are the problems, what are the potential, let's say, solutions at short terms, I mean, at long terms. But when you say that also without prejudice of the GDPR and also the impact of interdependence, what comes to my mind is to how the enforcement structure of the AI Act will also interact, with the AI Office position as the main enforcer for the general proposed AI rules. And I'm going to Claudio because I'm not sure if this will strengthen or weaken the fundamental rights protection. I mean, in a broader perspective, the decision to link the enforcement of the AI Act with traditional consumer frameworks, because we know that there is a very, very strong connection with product safety regulations and all the union harmonization legislation. So my question is, what implications does this have for consumer rights from your perspective at BEUC?
Thank you so much, Rocco, for the word. Thank you for the invitation. In general, I'm here on behalf of BEUC, the European Consumer Organization. For those who don't know, we are an organization, an umbrella organization here in Brussels. We are the consumer voice in Europe, and we represent 44 consumer organizations in 31 countries. And our main role is precisely to do, well, I think the name says it all, right? Consumer voice with the decision makers to make sure we have better policy outcomes. And this has been particularly one of the issues on which we've been very active over the past few years, the AI Act, because precisely of the consequences and impacts it has on consumers. And on that, I promise I'll keep it brief. I have no PowerPoint presentation, and I'm perfectly aware that we are the last thing standing between you and cocktails. So I will bear that in mind, especially when the house is this big. So going straight into, I would say maybe to zoom out a bit on the issue and start by the actual title of the panel here. We think this is not it's not mutually exclusive when we're talking about over-enforcement or under-protection. Most importantly, we don't really think over-enforcement is a thing. We don't really think this is actually even on the radar. I mean, over-enforcement, what even is that? Even if that was possible, what could possibly mean that we are over-enforcing something which is legislation? What could it possibly mean to say that, oh, we're going too far in defending people's rights. We're going too far in pointing out the illegalities that are going on. We're going too far. That's not really a thing. If there is enforcement, that means there is a violation of legislation, there is an infringement upon people's rights, and it is the duty of the enforcer not to take it easy, not to take a break, not to take a short Friday, to actually enact and go about it and make sure that rights are protected. This is pretty much how it works. And from our perspective, when we look at any legislation, I think this is also the case here on the AI Act, is looking at a reality in which, whether you like it or not, there is a framework which is indeed very complicated, with good reasons, very good reasons, but does leave us the lingering question. I think, Rocco, your doubt is very well justified, on which will we actually get better outcomes in terms of protecting people's rights, and most important, the fundamental rights of consumers. And from our side, that is still very much a question in opening, because when we actually look at the reality today, of course, it's still too early to tell how the structure is going to be implemented, but of course, starting with the AI office, of course, a very positive step, but of course, we still have very much fundamental questions on these capabilities, and to be honest, some lack of enforcement powers, the very resources that the Commission can have to ensure we have a full implementation is something we've raised very a long time ago. A lot of times the issue that we need to have proper enforcement resources at the European and national level. This is a question that is across the board, not just the AI Act, also DSA, DMA, and this is a question that is still clearly on. If we go to national level, I think when it comes to the MSAs, we also have this reality in which we're doing designations upon designations of national authorities that already are accumulating competencies without really accumulating or increasing resources. That leaves us a clear question on whether enforcement will actually be have the efficacy that we require to ensure that we have proper enforcement. And on top of all of this, we have a reality today in which we see that the very rules that are supposed to be enforced, which have been agreed by legislators very recently, are now even coming into questioning at the eyes of pretty much all the stakeholders and policymakers at the European level, because apparently consumers are the last barrier to advancing innovation and achieving economic growth in Europe. I mean, I like consumers very much. I pride myself on being one. I never thought to myself that my fundamental rights were a fundamental obstacle to economic growth and advancement of innovation in Europe. And I don't think anyone who looks at this clearly could actually portray this to be the case. So coming down to what we see today, there is a massive call for simplification. The Commission is indeed pursuing this political agenda. And here we have to actually say this very carefully. In the context of a policy that has just been rolled out, hasn't been even fully implemented, that we are already talking about questioning these very rules, does also not bode very well for the issue of proper enforcement on the long term. So this also raises very much fundamental concerns to us. You mentioned the code of practice earlier on. Civil society, including Milk, we've raised very significant concerns about the fact that there's been a downgrading of the issue of fundamental rights in the third draft of the code. This is for us another troubling sign of going against, to be honest, the spirit of the legislators when drawing the AI Act, if not against the AI Act itself. We see now with both Omnibus Digital Package, the potential rumors that we might go even further when it comes to ensuring that some of the rules that for us would be fundamental to ensure proper enforcement of consumers' rights are going to also be touched. So when we took back and we see this all overview, we are indeed very much concerned about the future developments. It's not just the fact that we know by a timeline, by the facts of the timeline, that enforcement of the AI Act is going to take a couple more years. It's also the general scenario that simplification, but also the signals from other digital legislation we're going on right now, in which we are also seeing that, let's take the DSA, for instance, a legislation that has been fully adopted, it's enforced, and still you see that no fines are coming out, no decisions are coming out. So even their enforcement is taking a slow beat. So you look at everything from a holistic perspective, and of course from our side, there is indeed a lot of reasons to be concerned. We hope that this concern will indeed be mitigated through time, and we really hope it. At this point, from our perspective, I think our main message right now must be that, especially for the Commission right here, that enforcement indeed will be priority, and it should not be considered. I think the President is completely wrong, and there's no such thing as over-enforcement. We need to have as much enforcement as we can, because with the resources we have, with the legislation that we have, most likely it will still not be enough to ensure that everything which is on the map, on the radar, can be detected, found, and tackled, and most importantly, to ensure that we can have a situation where we can ensure that the interplay between all the legislations that are going on right now can substantially work, because we can also not wait until AI Act is fully implemented, we have enforcement ongoing. We need to right now rely on the legislation which is in place that is fighting the original sin of many of the practices which are right now at the fundamental use of these AI systems, which is the unlawful collection of data. And this is why we need to keep this very much interplay with sectoral legislation, as you were saying, Rocco. The importance of the GDPR enforcement is fundamental. The DSA enforcement is fundamental, especially in the case of minors. Talking about cases of AI chatbots, for instance, the role of the DSA here is clear. So there is a fundamental need at this stage in time. We cannot just wait until AI enforcers start trickling in. We need to make sure that we have a clear interplay, a clear bet on enforcement across the board through all these digital legislations to ensure that we can protect consumers' rights now, not later. And as much as far as we can, not as little as we can, because this is not a trade-off. And I'm sorry to say, this cannot be perceived as a trade-off in which, oh, if we should enforce a little less because, let's close our eyes here and there. Let's let them do some things because, everyone has the right to innovate. And we hear a lot about these amazing AI tools that are going to be deployed everywhere else in the world in third countries, but not in Europe because our rules are not innovation friendly. From our view, it's clear. If we have rules that have been adopted and they're designed to protect consumers' rights, and we have these brands, basically, these companies basically saying, look, we would like to deploy in Europe, but we can. Well, I'm sorry, we don't think consumers are missing out on anything because you're not missing out on a product which is unsafe and a product that can cause you fundamental harms, and it is the own manufacturer admitting to that. So this is the narrative that is necessary that we invert, we put it upside down, so we have to understand that we need to make this policy consumer-centric policy, and if we really want to start building trust on AI, then we need to start putting people first and not systems, companies, profit models at the headweight of our policies. Thank you so much.
Thank you, Claudio. I noted down your sentence because this was particularly worthwhile to remember that sentence. The consumer has least barrier to achieve a stronger development for AI. So I think that it's something that we have to think about it. We're already thinking about it, but then the question is that if for real we have a lack of enforcement or an over-enforcement, and in this sense, also the decision to centralize in some way the enforcement in the EU Commission make me think if this is the right decision and what consequence will this have for compliance obligations. Pavel, I'm going to you because you are a lawyer, so, but also with academic background, so I know that you can tackle these questions about compliance obligations, legal uncertainty, and litigation risk for business, but also, considering that you wrote also about overlapping with the market authorities, I would like also to know more about, your talks about the national competent authorities under the AI Act and how this interacts and which overlaps we can, at which overlaps we can assist in the enforcement. Taking into account, of course, that the general proposed AI rules are at EU level, like Sabrina said, but we will see probably with you that even the market surveillance authorities have to cooperate with the AI office.
Yeah, sure. Thank you, Rocco, so much, and thank you for the invitation. Claudio, you are not alone. I also don't have presentation, so I hope I will convey my message clearly, though. So, firstly, I would like to say that with AI Office, we see a specific model of enforcement, which is, at least in my opinion, rather unusual for EU digital legislation. I mean, this is kind of a hybrid model in which we have national authorities or authorities at national level. Then we have a board, which was like the initial idea, and then mostly because of the rise of the GPTs in 2023 mostly, at the relative late stage of the AI Act legislative process, we've experienced the change to the model in which the AI Office was established within the enforcement framework, and to a certain extent part of the overall enforcement has been transmitted, let's say, at the European, at the EU level. And then AI Office is strange creature, I would say, because when you look at the definition of the AI Office in the AI Act, it's not separate body like its name might suggest. It's rather a function of the Commission, which is performed in a kind of like AI hub way, let's say. So we see a hybrid model in which it might be recognized that EU legislators decided to move part of the enforcement, maybe as a response to previously seen difficulties within other EU digital laws at the EU level, which might be similar to the case with the DSA to a certain extent, but still it's relatively unusual also for the product safety regulation, I would say. And then when we look at the issue of compliance, when we look at the issue of obligations, it might be from the perspective of the marketplace, it might be seen that certain level of centralization is good at first glance, because then we have like one player and we have to like look at what the authority has been doing. But then the main problem with the AI Act is the vagueness of its obligations. And it's not, again, it's not pertinent only to AI Act as a part of a digital legislation to be so vague, to be so fuzzy. I mean, there is like, this trend is driven by, one may argue, by technological neutrality needs, and other might argue that it's because there is a lack of political cohesion between EU legislators, and they simply kick the can down the road, and they make the de facto legal norms. I don't want to go into specific of the definition, the difference between rules and principles, but they just, the legal norms understood as a way of behavior in a specific situation that is prescribed by law. It is not decided by the legal text itself, but it is rather moved forward towards certain types of let's say, soft law. In the case of AI Act, plethora of standardization instruments. And what's interesting here is that in AI Act, as regards GPAI, we have code of practice, which is heavily discussed right now, but still it is only interim measure, because the ultimate measure should be harmonized standards under Article 40 of the AI Act, and currently there are works within ICOs focused on standardizations, but these works are focused on the standardization as regards AI systems, not AI models. So besides that, we might have so-called common specification under Article 41, and then there are other soft law instruments, guidance that might be issued with cooperation between national authorities, AI Office, and the board, and also codes of conduct, which are different than codes of practice. And codes of conduct under Article 95, they are focused, that they do not have the level of legal force that the other instruments might have. With this overview, we can see that what has to be done from compliance perspective, so from the perspective of making it operational at the level of the company, is yet to be in fact decided. And then there is a question about legitimacy, of course, of these instruments and the possible ways of judicial review and how the ultimate shape of what is recognized as a specific instruments that needs to be implemented to be found compliant actually are. So that's basically the problem with the legal obligations under AI Act as regards general purpose AI models. And moving forward to the issue of the cooperation and the position of the AI office towards market surveillance authorities, I would like to focus on Article 75 of AI Act, which provides specific provisions for 3 different situations. And the first situation is the situation in which when the same provider develops both the GPAI model and the GPAI system, and in that case the AI office becomes the sole enforcer. The second situation is that when deployers directly use a GPAI system for high-risk purposes, and in that scenario, market surveillance authorities at the national level are obliged to cooperate with the AI office to assess compliance of that system. And the third situation is that in case of let's say, blocked audits, I mean situations in which market surveillance authorities cannot conclude an audit of high-risk AI system due to lack of an access to model-level documentation, they may submit a reasoned request to AI office for let's say, support in this process. And then from this, we can see that firstly, there is layered approach to enforcement, but it is not the case that there is no clear delineation between the enforcers within the enforcement system, because in fact market surveillance authorities may prompt formally or informally AI office as a market surveillance authority for example, GPAI systems in the first scenario to take some action. And it is kind of like example of so-called extended accountability within the specific legal act. And I wrote with Professor Paul Dechert paper about it in the context more broadly about the digital regulation. So that's interesting, but it's more academic. So I will move forward, and yeah, I would like to. So I will stay with the concept of fuzziness of law, because then it leads to a situation in the norms creating power is transferred to the executive, to the branch of the government which is executive, in fact, because Commission plays such a role. And then, of course, it might lead to a risk of some kind of a political capture during the process. It might not. But then, when we look at the whole digital landscape, maybe the question, the underlying question is whether we should think about how we create the system of norms, and to which extent the legislative part of the government, classically speaking, is too vague in creating these norms, and whether there is alternative and how to measure potentially making the norms more specific, or how to provide the way of enhancing accountability and legitimacy within the system. So, thank you.
Thank you, Pavel. I think you gave us a general overview that we needed, because it's kind of technical regulation. We know that, and when we look at the data and at the AI Act, probably we look at that with the eyes of data protection experts. So, but in this case, as we saw with you, there is a lot of product compliance regulation. So I think it's useful also to see and to take this perspective. Now, without going further, I would like to open the floor for questions, because I think it's a very good panel, so probably you will have some questions. Yeah. Well, we don't have a microphone.
It's there.
Thank you very much, Cornelia Kutterer. I have multiple hats on, but maybe here I identify as a researcher of the Multidisciplinary Institute in Artificial Intelligence. I've also been an independent expert at the GPAI Code of Practice. So first of all, it's a great panel. I have a little bit to feel everybody has addressed an aspect that you could make a full session out of. They were a little bit different from each other. I would like to ask Claudia, eventually starting with Claudio, sorry.
Happens all the time.
If you, I don't know, of course, because no one knows who was involved in the COP, which is maybe already a criticism to the AI office. But if you have been involved, in case you or have been at least listening into the COP, if you want to identify as an expert, then how did you feel about the systemic risks when you also look at systemic risks in the context of the DSA, which are very, very different from the approach and how the Commission has defined that? That would be my first issue. And maybe to the whole group, when you, and this is a little bit because you mentioned the DSA, the GDPR, and the AI Act, but there's, of course, plenty of other rules, for example, around sexual child abuse image material, which for my whole career, I felt the Commission has always not paid enough attention to from the very beginning of the e-commerce directive, and where you see the line amongst those regulations for this specific topic.
Do we have more questions? Yeah. Oh, wow.
Yeah, better take a round. Yeah.
Thanks. It was a really great panel. I think you paint a really interesting picture of the amount of interagency or inter-administrative communication that needs to be going on between different boards, for the DSA, AI Act, GDPR, and so forth. I think you painted a really good picture of the, interactions that may need to go between the, the national levels, market surveillance, and the AI office. And I think when you multiply that by, the diversity and the throughput, perhaps if you might put it as discovery of risks, especially against fundamental rights, discovery of tests and mitigations that we might employ there. Do you think the current mechanisms for how the various bodies and agencies communicate is going to be able to deal with that? Will you not just be in interagency committee meetings the whole time? Does there need to be? And we actually heard, I think, one of the earlier the European Data Protection Supervisor talking about a digital clearinghouse, as a way of doing it. So I was interested in any opinions there. Is the current agency is probably not the quite word, but inter-official communication mechanism up to the challenge?
Yeah, I think we can collect all of them, and then we can. Oh, but there is 1, 2. Okay, 5.
Hi, thank you very much for the panel. I have a very concrete question for Sabrina, because I've heard contradictory opinions, both during CPDP and before, talking with people in the AI field. What's the actual effect of signing or not the code of practice by providers? Would it be just a tool anyway? Is it more of a symbolic effect, or does it have a binding effect for those companies that want to commit to it, or could they still follow the AI Act, comply with the AI Act through standards or other methods, which isn't the core of practice, even if they sign it? Thank you.
I think it's better if we start to answer it, because we have a lot of questions. So who want to start? Probably the first one was addressed to you, Claudio.
Happy to start. You want to put me in a tight spot, don't you? This is on the record, so all I can say is that we don't really do into speculations. So what I can tell you is that our position across the board has always been that the particular risks of this technology indeed would favor, from a prima facie point of view, that we would have a rights-based approach, similar to what we have in Article 5 GDPR. In the end of the day, what we had, as we all know, is it's a risk-based approach. But given that, that carries certain risks. And to ensure that we have some complementarity in terms of creating a proper safety net for consumers, in this case for citizens, because we were talking about really citizenship rights, what we're talking about here should be something that is indeed principle-inspired. There's clear principles like fairness, openness, accountability, and these are principles that will need to be reflected, across the board when it comes to, you can start with legislation, code of practice, guidelines, you name it, but also in decisions themselves. These principles need to be incorporated, and this is why the interplay with GDPR is so important, and I think what Sophie brought really shows you how the framework is indeed stacked to make it work as it does, because this is how we see it. It very much derives from this original sin. From what we see, with the issue about the collection of data, how this data is used, and all the downstream effects that this has. So we need to have these basic principles and our fundamental values in front and center when it comes to enforcing the Act. So this is like the very much basic line here. But I also heard something very interesting during CPDP, and I know basically running out of time, but I think I wanted to mention this. The panel yesterday, Mark Rothenberg moderated. One of the speakers, I don't know if it's remember which, did give us this very good necessity of a paradigm shift, seeing the comparison what we have today in administrative law and what we see, what the basic issues when it comes to the rights of citizens to have contestability of decisions, to have a right to receive an explanation of decisions made, the possibility to demand redress of said decisions, and to have a power of review. And it should be a no-brainer that these basic rights that are derived from law, offline, I don't want to like to use it this way, but it should be a no-brainer that these shouldn't necessarily be part of any framework when it happens online. It's not like there's some kind of invisible border, and if you go online somehow, these fundamental principles just stop to apply. Quite the opposite. It should be immediately reproducible, and this is reproductive, and this is the issue that we need to see going back to this legislation. As we need to go back to this principles-based approach. But going back to the transversal, actually no, I'll take a second step. I'll come back to the broader question that you asked. Otherwise, other people. Please go ahead. Moderate away.
Well, the second and the third questions, I think you can take it, right?
I can take the
Yeah, okay.
cooperation between
Yeah.
So actually, I believe it's a great question. I would say that it would be, how to put it, we don't have effective mechanisms for cross-regime cooperation, and it is grossly ineffective, I would say, in a current state. The reasons for that situation are two, I believe. The first is the legal one, because naturally EU law is constrained by the institutional and procedural autonomy of member states. But like any principle of EU law, it is more or less flexible to a certain extent, and we can see instances of this principle being stretched, I would say. And the second reason is that, just my intuition, the second reason is that it might be easier not to have to deal within legislative process with discussions with, for example, member states, where we should put the enforcement power. So it might be, that's my assumption. I never worked for this during such process, but when I look from some perspective, then it might be the case that's just the easier way to just adopt the law. But the point is that we don't have effective cross-regime cooperation mechanisms, and there is no overlap itself is not a problem. I believe I agree fully with Sophie on this. The problem is the number of the nodes within the network and whether we can gain advantage out of it, and whether it becomes a burden. And how to find the line? This is the question. This is difficult. I don't have clear answer for this. But again, I would say that digital clearinghouse mechanism, as it has been presented, 2.0, because the first edition was in 2016, it might be promising, but it is initiative by the EDPS, and my intuition again is that it would need to have to get some support from the other institutions within EU system to get enough traction. But this is the path that might be taken given the current EU constitutional outlook, and it might be done, but the question is whether there is like true willingness to do it. Thanks.
Rocco, can I add? Just to add to a note on this, so I spend part of the morning with digital services coordinators, and are trying to understand what is that they should be doing and how they should be interacting with DPAs. Because for DSA, there's lots of also patchy allocation of competences. They were not. Of course, they have many questions, but there is willingness, and people are starting to speak about MOUs, and there is already some agreement on some collaboration that needs to happen at certain points. So DSA is older than the AI Act, but yes. Some things can be done. Then it becomes problematic when obviously there is also the Commission that is on top and is trying also to drive efforts. And not everything that is being issued by the European Commission clarifies things. And just to pick an example that is not seasoned, but minors, the recent guidelines that we've got on minors just do not really align with what they should be thinking about. So there's lots of pieces and puzzles, but we are not all doomed, I'd like to think. And it's starting in other chapters, so hopefully well, we shall see what the lobbying is going to do for us. But yes, there are tools. Now we just need to use them.
I think there are 2 more questions, right? One there.
I think there was a question that was directed at me as well. So I'm gonna,
sorry.
reply to that. So the question was about the effect of signing the code. There's more written down on this if you look at the guideline consultation that we had published that closed yesterday. Broadly, we know that the AI Act rules for general purpose AI will apply in any case from August 2025, because that's part of the AI Act. So the code of practice should be a voluntary tool first to demonstrate compliance with the AI Act. So providers can choose to sign up to the code or not. It's important to understand that the code itself first needs to be approved by the AI office and by the member states through the AI board. So then it becomes this tool to demonstrate compliance. If a provider, and this is what we wrote down in this consultation, so the preliminary approach is that if a provider signs up to the code, then this can be quite beneficial to this organization. So the idea is that if you sign up to the code and you adhere to the code, then you face less administrative burden from the Commission, because the Commission puts forward more trust towards that organization compared to an organization who does not sign up to the code. If you do not sign up to the code, then you would need to demonstrate compliance through other means. And here, the code can really serve as a straightforward way that spells out what you would have to do to show how you comply with transparency and copyright obligations, but also with the systemic risk part. And so it's really an offer to providers to use this as a very straightforward tool, while otherwise, of course, they can also demonstrate in their ways how they comply with the law. One point I wanted to touch upon, because it was raised in other presentations as well, is the point on the risk taxonomy that's currently being detailed out by the chairs and vice chairs. This process is designed to be as transparent and inclusive as possible. I know it's quite difficult. It is different from other codes where companies were part of the drafting team, let's say. This time it's independent experts holding the pen, and there is a possibility for this room to discuss the code, because it's every time in each drafting round it's being published, and there is this room for engagement. The chairs, as we understand it from them, regret that there's some misunderstanding with regards to the risk taxonomy. So the idea is that fundamental rights are being considered, and they're taking into account the feedback that they received from various stakeholders. So it's great that we had this iteration, I would say. Yeah, that was everything I wanted to say on the code. Thanks so much for all your input.
Thank you. Well, we can take the other questions now.
Yeah. Hi, thank you for the interesting discussion. So my question is to Claudio. You mentioned that is over-enforcement even possible? So in theory, I agree with you. But in practice, legal interpretation is never black and white, and it's always 50 shades of gray, right? And even with GDPR, you had the Dutch Supervisory Authority, for example, say that legitimate interest cannot be used as a legal base for commercial interests. And in practice, we also see that there was also a case law which said that if you have done pseudo-anonymization, but if you don't share the key with the receiver, for the receiver, the data is anonymous. However, in practice, none of the contracts ever reflect this reality, and you always have to negotiate on this after reflecting the case law. So given that, and from a provider's perspective, my question is from the provider's perspective. So given that how the AI Act is so vague, don't you think that European providers have a legitimate fear of over-enforcement? And yeah, maybe they think the Brussels effect is too much for them to handle, and the San Francisco effect is better, probably, for their company's perspective. What do you think about it?
Yeah.
More questions?
Do we have more? No. Yeah. Yeah. You can ask, and then
Okay.
we will try.
No, my question is regarding the threshold established in AI Act to trigger the systemic to trigger the systemic risks obligations for GPAI models. So I was wondering whether this threshold is going to be reconsidered or reevaluated, and why it was not considered, for instance, the threshold used on applied in DSA as the number of the users, and instead it was considered the size of the model, because as the AI models are being used for content generation and as information retrieval tools. I know that DSA might have more effective measures to tackle those risks, but to what extent the AI office is willing, and which tools the AI office is considering to tackle those risks under the AI Act?
Okay, I think you have like 1 minute per each, so very fast.
I'll go first. I'll take the first part, the last part first. Because it actually reminds me, I forgot to answer half of the question from before, the first question. This is a very good question. We actually replied to the consultation yesterday as well. Thank you so much for that opportunity to the Commission. Again, this is precisely the risk or you take when you go from rights-based to risk-based. Then you have to define what exactly constitutes risk, what exactly constitutes systemic risk, and it's important to have that consideration so you can ensure that those players that have the biggest capacity to inflict the greatest amount of harm can be designated and considered. And that's also the risk when you have thresholds like what you're saying right now. And from our perspective, is an arbitrary numerical value, an arbitrary threshold always risks to be unfair in one way or another, but most importantly, it risks leaving out relevant players that otherwise should be considered. So in this particular case, I mean, our position is very much there should be some kind of complementarity to ensure that there is indeed a safety net, because in this particular case, compute isn't everything, and some things in life, size isn't everything, okay? So size really isn't everything. So you need to have some kind of complementarity that ensures that even though some systems might not really meet that threshold, but actually analyzed, they can still have the potential to produce significant harms, they should indeed be considered. So we should have that possibility, and because I'm being rushed by Rocco, I'm just going to answer the gentleman over there. I appreciate the concern. I mean, I'm not saying, of course, that these risks do not exist, but I think there's a fundamental misconception between what is exactly maybe a lack of harmonization practices of actual enforcement and what is indeed too much enforcement. And I think that is actually connected to the whole point, which is the simple lack of resources and of manpower capability that regulators have, both on member states, EU level, and that's why it's absolutely fundamental to ensure that when we have over-enforcement, we're not just talking about that we need more action. No, we need more staff, we need more capabilities, we need more resources, we need more critical minds to actually join the process and ensure that we can have a better regulatory environment. And on that, just to bring some fish into my table as well, the creation of synergies, this beautiful word from Brussels. Don't be afraid to bring in the expertise of civil society. Don't be afraid to rely on consumer organizations, for instance, that do amazing market monitoring and analysis of digital rights organizations, academics. Tap into that existing resource to complement and ensure we have a better market monitoring, because indeed this is all the tools that ensure that we can also help to have a better ecosystem, because at the end, it's this that nudges economic operators to being kept honest, to actually deliver better products. Because code of practice, good or not, with all due respect to the Commission, as an enforcer, and I'm going to steal this from a colleague of ours, but it's a good sentence. As an enforcer, if I'm one of those providers, I should fear you. I should not expect from you just dialogue, tea and cookies and some voluntary commitments. That is good. That's a complementary thing. That's as good to have. It's a nice to have. But a must-have must be clear fundamental rules that must be followed, and the clear stick, the carrot and the stick, knowing that if I do fail them, step outside of the line, I'm going to be kept honest. And that is the nudge that makes sure that we have a better ecosystem and a better environment overall. Thank you.
Thank you so much.
Thanks so much. And I think from August, we'll see what the enforcement approach will look like. Just to be sure on the point that you both had made, when a model is considered with systemic risk. So actually, the AI Act foresees that it should not only be about the flops. So this is like the presumption that a model might pose systemic risk, but actually the Commission can also designate models, and here explicitly we should take into account the number of users and business users, in addition to other questions like how autonomous is the model. So it's very much foreseen in the AI Act that we do look at these questions as well. So do hold us honest to the AI Act, and thank you so much for today.
Thank you. Thank you so much all for being here today. So now we can go to the closing remarks, and then we can continue the discussion with some drinks. Thank you.
Thank you.
Good job.
Likewise.